you heard the results.
I only heard
Positive
the
for everything. Lori,
Lori.
your client was positive for methamphetamine, fentanyl, cocaine.
Hold up. Meth, fentanyl, cocaine, and marijuana? That's not a drug test. That's a chemistry final. You don't need a lab report. You need a forensic intervention team.
And perhaps something marijuana.
Does Autumn have the test results or something?
No, one of the issues is just terms. But her report back to the court was positive.
So it's meth,
Methamphetamine, marijuana, fentanyl.
doesn't show cocaine.
No, it doesn't. It's an instant test, so the levels would have been high. Because it's not a very discriminatory test.
Well, I'm watching.
The defendant was here on May 7th for a pre-exam conference with Mr. Truckee, and indicated at that time he was to have a preliminary examination. So the preliminary examination was for May 20th.
Let's be real. Skipping court while the officers are sitting there prepped to testify is like ghosting a job interview while the CEO's waiting. Only worse, because this ghosting ends in handcuffs.
And we're going to represent what was told so anybody could correct it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here to testify, much to the consternation of all of us, including me. So I issued a bench warrant and said bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. Unbelievable. Following the days missed. I thought it was Wednesday, 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at the hearing. He called the court after the 20th. So in the afternoon of the 20th, so I missed my court. So well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th, Tuesday, and the 20th, he didn't show up. He was actually in the courthouse, paid on some fine. So he didn't show up on the 20th. Then he presented himself in court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in. My understanding is, and correct me again if I'm wrong, he went to the jail and sat there for about 45 minutes. He said they were too busy to book you in. Is that true?
Yes, sir.
So you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door. You walked in the door. So he was gone. We tried to call him, but he was already on his way to 3 rooms. So here you are. I canceled your bond. It was my bench warrant. There's a statute that nobody likes, but it's MCR 6.105. It's actually important.
Here's your legal gem of the day. Under Michigan Court Rule 6105, if you voluntarily show up on a warrant, the court can't just treat you like a fugitive. It's basically the legal system saying, okay, points for showing up, barely.
If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant. The court is available to do so within 2 hours of the defendant presenting himself. So he then to the court between the date, called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept it. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk or appeal, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call, so he was running late, but he was. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash surety that was in effect. So, it's like, okay, no counsel was here. Just simply wasn't available. Mr. Truckee had left. Didn't get notice.
When prosecutors go full scorched earth on judges behind closed doors, that's courtroom drama off the record, with a side of ego and a splash of insubordination.
The prosecutor, I simply scheduled that this morning. And then went on back about my meetings. I had other stuff to catch up from being on vacation. So some point later this morning, Mr. Gabriel came into my chambers. I was in there signing some orders. I said, hey, good morning. I got somebody I'd like to talk to you about. I had a misdemeanor complaint that's handled by their intern, and I wanted to check with him on it. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR? And didn't have an instant response. I just recalled the bench for us. So then I said, well, I guess I'm sorry I didn't get your notice of the proceeding, but he just showed up. And I cited the courtroom. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there for us. And so I left sitting there thinking either me, now maybe the statute is in the court rule that there's a presumption that they turn themselves in, that they're not a flight risk. If I had done that when I was the prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor can come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you'd do it to Judge Stutzman. I don't believe you'd do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I sent the man here. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel his bond because Kerry Gabriel is mad. And I didn't deserve what you came in and said. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, how long do I have to be a lawyer before I can be as much of an asshole as Gary Gabriel was? I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did. And he's here now.
And just like that, we're back on track. Bond reinstated, tempers simmered, and a drug test on deck, because in this court, even chaos gets its own docket.